And good morning. You know, there may be, well, State Question 788. The world has changed a whole lot. John Williams with the Bar Association, good to have you here.
Good morning, Scott.
You help people, Bar Association, bar members. State Question 788 passes. It has an impact not just on people that are wanting to get medical marijuana, but folks who seek legal counsel. Tell us about what problems you're facing.
Well, under our current rules of professional conduct, a lawyer is prohibited from giving advice on criminal activity. And marijuana is still a Schedule I drug under the Federal Controlled Dangerous Substances Act. So therefore, it's illegal under federal law. And while the feds have deferred prosecution by amendments to the Appropriation Acts and prohibited the federal prosecutors from using federal funds to prosecute in the legal marijuana states, that actually runs out September the 30th, but that's a policy statement. That law still remains on the books. And so we're looking at amending our rule so that lawyers can professionally and without putting their license in jeopardy, advise people on all the facets of this business that has now been created by vote of the will of the people. And we want to do this, I call it RLL. We want to do this right, we want to do it legal, and we want to do it once. There's a lot of things still in play with this, with rules, regulations, perhaps legislation, and now I understand there's a couple of lawsuits. And we want to make sure that we're right in the way that we move forward so that lawyers can give competent, good advice. We want to make sure it's legal. We want to make sure that we're in line with the law as much as possible, and we want to do this once. We don't want to create confusion by this becoming a moving target. We want our members to be able to competently and assuredly assist and advise the public, because every facet of business is going to be involved in this. And it's not just growers and dispensers and how that all works out, but landlords. When I was in practice, every lease I drafted said that the tenant cannot be involved in any illegal activity or the lease is invalidated. We've got to learn how to now draft leases that take this into consideration. Federal law says that anyone who does more than $10,000 in a relationship with someone in this business could be subject to federal money laundering and a $20,000 fine. We've got banking institutions that may or not be able to take money. So if a client is to give a retainer, when the lawyer puts that in the trust account, is that money then become in jeopardy of being confiscated? So when I say we want to do this right, we want to do it looking at everything that's out there. We want to do it in a way that's legal so that everyone's protected, and we don't want to do it once so that we don't confuse or we don't have to redo anything.
Sounds like you got some rules to change. It's good to see you, John Williams, Oakland Bar Association. Thanks very much for being here. See this again at news9.com/yourvotecounts. We'll be right back.